Καλησπέρα σε όλους. Ξεκινάμε ελληνικά, να σας χαιρετήσω. Περίμενα λίγο για να μπουν και κάποιοι άλλοι, γιατί έχουμε πολλούς εγγεγραμμένους. Υπάρχει μία συμμετοχή, αλλά υπάρχουν και άλλοι που θα μπουν. So, now θα γυρίσω στα αγγλικά, ώστε να τιμήσουμε και τον κύριο Nordemann. Good afternoon, everyone. Welcome to today's webinar on copyright and artificial intelligence, organized by the Hellenic Copyright Organizations under the auspices of the Greek or the Hellenic AIPPI group. It's really an issue that everybody is talking about, whether it's in the copyright field or not, AI. So we are gathering here at a very pivotal moment, I would say. Artificial intelligence is transforming how creative content is produced and consumed, raising some fundamental questions about the future of copyright protection. How do we balance innovation with creators' rights? What happens when AI systems are trained on copyrighted works? And who owns that what AI generates? These aren't just theoretical questions. They are being decided right now in courtrooms, legislators, and international forums around the world. So before we dive in, I am pleased to introduce you to Dr. Nikolaos Liberis, that he is a lawyer and managing partner from the law firm Vagiannou Kostopoulou Liberis and president of the Hellenic AIPPI group, who will deliver our welcome address. Mr. Liberis, the floor is yours.
Thank you, Mrs. Papadopoulou. Dear colleagues and friends, thank you for joining us. Dear Mrs. Maria Daphne Papadopoulou, Acting Director of the Hellenic Copyright Organization, on behalf of the Hellenic Group of AIPPI, I would like to thank you for hosting and coordinating our joint event. The rapidly developing artificial intelligence and its impact on all branches of intellectual property is huge, but to a considerable extent, still unforeseeable for the near future. This is the case especially with regard to the so-called superintelligent systems, their potential autonomy. Specifically regarding AI's impact on the rights of creators and copyright owners, numerous questions of high importance in everyday life need urgent responses in theory and in practice. Points worth being addressed are, for example, under which conditions the involvement of AI in training AI systems or AI models with copyright-protected material and delivering AI-generated output could constitute a copyright infringement. Another challenging area of action would be the necessary legal framework that, in addition to the already well-known EU AI Act, will have to be introduced on a cross-border level in today's digitally interconnected world. In this context, do we need to redefine, respectively reconceptualize abstract legal notions, abstract legal terms? Such terms could be beneficial exceptions, public interest, opt-out of copyright owners if any national law would permit use of AI for training purposes without prior authorization by said right owners. And how fast must this regulatory update be completed while AI is spreading across the world, and so on and so forth? Today, we are keen to listen to the highly qualified and esteemed Professor Dr. Bernd Nordemann, whom we are thankful to for his availability and time, and learn from his experience in this field of law with reference to the resolution issued by AIPPI in Yokohama earlier this year. I hope you all enjoy the presentation and discussion. Thank you.
Thank you, Mr. Ilberis. Now also it's my great pleasure to introduce our main speaker, Professor Dr. Jan Bernd Nordemann. Professor Nordemann is a leading authority in copyright and media law, and served as a chair of the plenary session in AIPPI's World Congress in Yokohama. Today, he'll present the AIPPI resolution on copyright and AI adopted at that Congress. And it was, let's say, a special bonus since we had this very interesting development. In the meanwhile, he will also provide some commentary on the landmark German decision, GEMA versus Open AI. First of all, I would like really to thank also for personally Professor Nordemann that he accepted to also to devote some time to us and to let's say explain some things and also inform us about this resolution, and also to say that Professor Nordemann, he is, of course, afterwards his presentation, will have some questions, but he is willing also, please correct me if I'm wrong, that also during his presentation, if there is anybody that, you know, wants to something to clear or to be explained more, he's willing, let's say, to make it a little bit more interactive. So whoever has a question, even during his presentation, I will try to lead all the thing to moderate it and to coordinate it. So in order to have it more interactive, if it's getting a little bit too busy with the question, we will leave all the questions for the end. And also I want to say that it is this webinar is recorded. So after all this, Professor Nordemann, welcome, and the floor is yours.
Thank you so much, Daphne, and also thank you, Nikolaos Liberis, for your kind introductory words. It is really a great pleasure to speak in front of the Hellenic National AIPPI group. As I already confessed to Daphne, I've never been to Greece, probably the only German that has not been to Greece yet. But of course, I have to do this at one stage. And so maybe doing a digital seminar in Greece is the first step to Greece for me. So I'm really delighted to do it.
The next time will be in person. This is that's a promise.
And I'm very delighted. And as Daphne said, please ask your questions right away if any questions arrive from your part. Otherwise, there's also time to ask them at the end, of course, during this 1 hour lunchtime seminar. I will now share my slides. Let's see. Oh. Okay. Just see, I have to check one thing. Well, okay. So let's start with the AIPPI resolution 2025 from Yokohama, where, as Daphne has already pointed out, I had the great pleasure to chair the plenary session and lead the plenary session to a resolution which I think is very interesting for all copyright lawyers that are interested in the relationship between AI and copyright. I will also touch base on the Munich judgment, GEMA Open AI, which you may have heard of. It is a well-observed decision. Of course, it's just the first court level in Germany, but it's one of the first AI decisions around the world, and I think the first decision in Europe that really goes to the heart of copyright and AI. So this is the resolution. Of course, it's only the beginning of the resolution, the start of the resolution on AIPPI and copyright. If you're familiar with AIPPI's work, it's a usual thing for AIPPI to work on resolutions, generate resolutions, and then publish them on different fields of law, in particular in copyright. There's every year there's a copyright resolution on an interesting copyright topic, and this year, 2025, this resolution was on AI and copyright. Resolutions are always preceded by so-called study questions of AIPPI, where AIPPI puts out a questionnaire to the national groups, and then this questionnaire is answered by the different national groups. For example, the German group has put in answers to the questionnaire, or the Italian group, which I found particularly interesting as well and referenced here, also around the world, really. Answers came in to the questionnaire from Australia to Canada to the US, Brazil. Why do I mention this? I think for anybody interested from your part in AI and copyright, this is a great library. So whenever you want to know something on AI and copyright and how it's handled in Brazil, for example, on Argentina, on Australia, on Germany, or on Italy, you just have to go to the AIPPI website, look at the 39 different national reports received, and you will find the answers. So it's, I think, a great possibility to retrieve information here on AI and copyright, also from the national level. On the AIPPI level, the different 39 national reports were distilled into a summary report that you will also find on the AIPPI website. And then at the Congress in Yokohama, Japan, this all led to the resolution I will now present to you, and which you can also download via the link indicated here. Just by the way, you don't have to write anything down. I will provide Daphne with the slides after my talk. Excuse me. And then anybody interested in the slides, I'm sure Daphne will provide you with the slides if you're interested in them. What I will also speak about, excuse me, as mentioned before, is the judgment by the Landgericht München, which is the regional court Munich, a first court level court in Germany. It is a very fresh judgment of November 11. It is of GEMA as a plaintiff against ChatGPT, operated by OpenAI. And we will see what the court held regarding the issues that are also laid down in the AIPPI resolution. If you wonder what im Namen des Volkes means, it just says in the name of the people. And I'm sure that's the same in Greece, that courts always rule in the name of the people. And that's kind of the header of every German judgment, with a Bavarian logo here on top of it. So what was the GEMA OpenAI case about? GEMA, ChatGPT, how you ever want to name it. The case is about copyrighted song texts, so lyrics. ChatGPT was trained with these lyrics. And it was possible with simple prompts to repeatedly generate the lyrics in identical form, in the ChatGPT output. So you put in prompts like, what are the lyrics to, a certain song title? Who wrote the lyrics? What is the refrain of this and this song title? Please also tell me the first verse of the song. Please also tell me the second verse of the song. And ChatGPT generated the lyrics for it. So that's the case. And it's particularly important for the case that through very simple prompting, it was repeatedly possible to generate the lyrics in identical form in the output. If you're interested in reading the judgment, there's a German original also available here through the link indicated. And you can then maybe use an AI translation tool to translate it into Greek. It's a quite long decision, but this already shows that the court really made an effort in reasoning its decision well. Let's first go back to the AIPPI resolution. The first part of more or less every AIPPI resolution is always the question, do we want to harmonize international law in respect of the resolution? So here, do we want to harmonize international law regarding AI and copyright? And the clear answer of AIPPI is yes, we should harmonize international law when it comes to AI and copyright. As you can see here, harmonization on the issue of one, use of copyrighted material in the training of an AI system, and two, the implications on whether the AI system itself and or the output of the AI system can be considered an infringement is desirable. And I share this view very much. I think to avoid, in particular, a race to the bottom when it comes to copyright rules, we should have an international minimum level, at least, for copyright in the AI area. There's a second part of the resolution which covers AI training and how international rules should look like for AI training and copyright. So the first very general statement of AIPPI was that AI training should require the prior authorization from the copyright holder, unless such use is covered by one or more of the following exceptions. You may think, well, this is kind of self-evident that AI training is a copyright relevant use, in particular a reproduction. But maybe that's not the case in all the countries of the world that have a copyright regime. So for AIPPI, it was important to emphasize the general rule that AI training is something that is relevant under copyright law, and you need a consent from the copyright holder unless there's an exception to copyright covering it. What exceptions did the AIPPI resolution look at? The AIPPI resolution first looks at a non-profit exception for the sole purpose of the public interest. So AI training should be allowed when this is not for profit, so when the training is not for profit, and for the sole purpose of the public interest. There should be, AIPPI says in international law, there should be an exception to copyright law, not for profit AI training and for the sole purpose of the public interest. Interesting, I think, to compare this to EU law, and in particular to the text and data mining exception in the DSM Directive 2019-790, and here Article 3. Article 3 of the DSM Directive says, member states shall provide for an exception for reproductions made by research organizations and cultural heritage institutions in order to carry out, for the purposes of scientific research, text and data mining of works to which they have lawful access. And research organizations is defined in the definitions section of the DSM Directive as a not-for-profit organization or by reinvesting all the profits in its scientific research. So what AIPPI has proposed is something that gets very close to Article 3 DSM Directive, I think. So that's nothing. I think the AIPPI resolution here in the area of not-for-profit doesn't really propose anything new to EU copyright law. The AIPPI resolution then goes on to further propose the following. If the laws of the relevant jurisdiction permit training without the prior authorization of the copyright holders, then the copyright holders should have the right to opt out of such use, and where the copyright holders do not exercise such an opt-out, there should be financial compensation to the copyright holders. To put it in my words, maybe AIPPI proposes as an international rule that there is, that in case there is an exception to do AI training, which has an opt-out option for the copyright holders, then in case they do not opt out, the AI training should be remunerated. And if you go into EU law and compare this, this proposal by the AIPPI resolution, I think it comes down to the following result. AIPPI would accept Article 4 of the DSM Directive. Text and data mining exception would be accepted as a general rule to do commercial, in particular commercial AI training. But in case you do not opt out, you have to pay a compensation as the AI training company. So there's something in addition. The AIPPI resolution says, well, EU law in Article 4 for commercial AI training is fine, but there should be a compensation paid in case you do not opt out and AI training is allowed. I find that interesting because Article 4 is under discussion at the moment in Brussels in particular, if it should be opened by the legislature at the EU level, and if a compensation rule should be included in case the copyright holders do not opt out of AI training. So that would kind of, maybe the AIPPI resolution would kind of fuel a bit the public, the discussion, the political discussion going on in Brussels at the moment in favor of compensation in case the right holders do not opt out of Article 4 DSM Directive. Yes.
So may I pose you? And so they consider in AIPPI quite successful the Article 4 and the opt-out rule, but they want a little bit, let's say, just to make it more clear that that compensation is needed. This is, let's say, one for me, just to make it really clear. And I had another comment in the question in the chat asking for the previews that they say that the not-for-profit that you mentioned before may be problematic if, for instance, scientific models later become commercial. Don't you think? So questions just to
maybe go back. Thank you, Daphne, for highlighting the question in the chat. It's sometimes difficult when you speak to look at the chat at the same time. Yes, that is an issue. Definitely, if the model trained on a non-profit basis is then later used for commercial purposes. So what AIPPI thought was that it should really be the sole purpose of the public interest, and not for profit all the way down. Which would of course mean that as soon as you start using the model also for commercial purposes, the training gets illegal. At least it is no longer covered by the exception, which may cause a later new assessment, legal assessment of the entire AI training. Whether that works in practice would need to be seen. But I share the view of Mr. Dagan's of Mrs. Dagan's comment that it's. I think you have to make up your mind. Non-profit must mean non-profit all the way. Maybe I would, just as a comment, also highlight the German Lion decision, which was published last year, where the German Hamburg court, which decided the Lion case, was a little more generous with Article 3 DSM directive exception, saying that as long as it was the AI training was done by a non-profit organization, it would not rule out Article 3 that also commercial users would use the training data later. But I think that is not convincing because it's too generous, I think, regarding Article 3. But we will have to see what the appeal level says on this opinion by the Hamburg court in the Lion case.
Okay, it's expected also within the first days of December?
Oh yes, very true. I think on December 10 it is expected, if I'm not mistaken. So it will be very soon. The Court of Appeal decision will be out in the Lion case. Okay. And maybe we will know more about how to interpret Article 3 of the DSM directive then. Yeah, I think it's very likely that they will say something about Article 3. Okay.
We have another question. I don't know if you want a last question from a professor of law and statistics, copyright law in the law school in the university here in Athens. And he asked, how could we define the debtors of the fair compensation? Almost everyone uses AI systems. I don't know if you want to answer it now or you have something relevant to answer to this question later.
I will give it a try, Daphne.
Okay.
It's a good question, of course. When you say compensation, you should also provide a solution for how to collect the compensation and how to distribute it. Yeah? And my idea would be to do it in the same way. To have maybe two choices. If you do not do individual collection, if that is not possible, because maybe the right holder is too small and it would be too burdensome to do individual collection, you could do it through CMOs, through collective management organizations, a little bit like the private copy levy. Yeah, that would be the idea. Of course, we cannot go into the details here in this lunch seminar, but CMOs, I think, could be one of the solutions to this. What AIPPI also said about AI training is that you always have to look at the three-step test according to the Bern Convention, Article 9, to Bern Convention, which is also, the three-step test is also an Article 5.5 InfoSoc Directive, 2001-29 in EU law. So it's a kind of a principle also of EU law. And I think this is a very important statement because it kind of limits the scope of the exceptions to a certain extent. In particular, at least my point of view would be that the three-step test rules out training and then a use for competing output competing with copyright owner, which could be in particular relevant for example, for the news industry, yeah, where you train with newspaper data and maybe create a competing news AI model. I think probably the three-step test would rule such uses out, and also training for such users. So just as an example to emphasize that I think AIPPI's statement in favor of the three-step test is kind of important here. What is also important is transparency, because maybe any copyright infringement in AI training that you didn't follow the requirements of the exceptions provided for AI training, so you do copyright infringing training, you can only detect this in case you know that they used your copyrighted works. So you need transparency on what was used for AI training. And the AIPPI resolution was also quite determined on this, and and I think quite right-holder friendly, saying that the provider of an AI system or person, entity that trains an AI system must provide adequate information regarding the copyrighted works used in the training of the AI system to enable copyright holders to identify the use of their works and exercise or enforce their rights. The same is true for input by user to the AI system and used by the AI system for training. If you compare this to EU law, you have to go into the AI Act, Article 53(1), letter D. The language there is, providers of general purpose AI models shall draw up and make publicly available a sufficiently detailed summary about the content used for training according to a template provided by the AI office. So EU law requires a sufficiently detailed summary, while AIPPI requests adequate information to enable copyright holders to identify the use of their works. I think AIPPI goes further than EU law, because a sufficiently detailed summary may not indicate what works were really used, because you can summarize. It is still a little bit unclear what sufficiently detailed summary in EU law really means. There's no template yet by the AI office, but of course we are all looking for that. And but in order to work for the EU transparency rule, in order to make it work, I think a narrow interpretation would be very helpful, that really enables right holders to identify if their works were used. So what about AI training and the GEMA OpenAI decision? I think what is at first interesting is the GEMA decision says Article 4 DSM directive applies to AI training. OpenAI is a commercial AI, generative AI model. So Article 4 applies to it. It is not 100% clear if Article 4 applies, but as the LL.M decision we mentioned earlier by the Hamburg court from 2024, also the GEMA decision of 2025 of the Munich German court relies on Article 4 as an exception for AI training. So at least as a general rule, it allows Article 4 to apply. But oh, sorry, that was, I hope you can read it nevertheless. That's a little mistake, like in the design of the slide. But the case was not about in infringing AI training, because GEMA did not really invoke illegal AI training. Rather, GEMA invoked that there was a permanent copy in the ChatGPT model that memorized the lyrics at trial, and the Munich court held that indeed ChatGPT included a permanent copy, which means a reproduction in copyright law of the lyrics. The court left open how the memorization works in detail, but as a quote, the court said, the crucial fact is that the song lyrics, which served as training data, are reproducibly contained in the model and thus embodied in it. So that's why I said in the beginning when I presented you the GEMA case, that it is really crucial in the case that with easy prompting, you could not only get out the lyrics once out of ChatGPT, but you could, do this repeatedly. Yeah, you could just put in the same prompts, and the lyrics would come out again. Yeah, and that's why the Munich court said, well, there's a copy inside. There's a copy inside, a permanent copy inside the model. A little bit like a DVD and a DVD player. Yeah. Of course, if you look at a DVD and you open it, you open the packaging, or you look at the DVD and you will not be able to see a film. You need a device in order to access and make viewable the film which is on the DVD. And so the Munich court followed this model and said, ChatGPT is a little bit like a DVD player. It has the DVD inside that is not readable for human eyes, but the model as a device makes it perceivable for the user. Yeah, so this would be indirect perception, and that is why you have a copy in the model itself, a permanent copy, which is not covered by Article 4. Article 4 only allows temporary copies for AI training. It doesn't allow permanent copies. There's also no other exception that would be available for ChatGPT to allow a permanent reproduction. Yeah.
May I ask you something now?
Yeah.
I am sorry. I make abuse maybe of my position here, the possibility to ask you. I don't see any questions here. Probably that's the reason why the GEMA preferred to, let's say, use this kind of element of memorization instead of proving the training. So they bet, let's say, on the memorization thing, so creation permanent copies, because they thought that it would be easier to prove it and probably also to convince the court.
Daphne, exactly. You're right. All my, discussions also we were not involved in the case, but I spoke to GEMA's general counsel about this, and he confirmed that the goal of GEMA was really to avoid Article 4. And a very easy way out of Article 4 is to show permanent reproduction, because that's not covered by Article 4. One of the reasons also to avoid Article 4 is an international conflict of law problem. Because if ChatGPT trained on US servers, the training will not have taken place in Germany, so German copyright law would not apply to the training. Yeah, that's the next reason. While the permanent copy in the system, GEMA could go after because there is a server of ChatGPT in Germany. And so they have kind of the country of protection principle allows GEMA to sue for a German copyright infringement because of the ChatGPT server being located in Germany, kind of where they kind of do the outputs from. Not the training server. The training server probably was outside Germany, but the output server, the model server that kind of generates the output, not the output server, but the server with the model, one is at least Frankfurt-based, so German copyright law could apply to the question of the permanent reproduction. That's also why it was kind of clever for GEMA to go after the memorization in the system and not after the training itself.
Thanks.
There's a second pending case that I just wanted to show to you, and I don't know if this works now, but maybe. Do you hear the song, Daphne? Do you hear any music? No.
Now, no, but before it was something I could hear something.
Okay.
No, now we cannot hear anything. When we tried, and it was possible to listen to this.
Yeah, I tried to. Well, if it doesn't work, I try to
sing it by yourself.
Yeah, okay. Maybe I don't want to spoil the event.
Yeah.
So it's. I could have played you. I think it doesn't. I can maybe give it a second try. I think I have no option to make the sound available to you. So anyway, there's a second case pending in front of the District Court Munich, in front of the Landgericht Munich, by GEMA against Suno. Suno is an AI music company that generates AI music. And also here, GEMA was able, with very easy prompting, to generate more or less identical copies of pop songs, like the song Daddy Cool, I don't know, that's a 70s, I think, song, of Boney M. You may also know this song in Greece.
It's quite known in Greece also, yes.
Okay, so go to the GEMA website. They have samples of the songs that they could generate with easy prompting, simple prompting out of Suno. So I think that this pending case will come out with the same result. A permanent copy in the system, which would then, of course, infringe the copyright in the compositions, and in the text as well. So that's just, a little flagging of another pending case, which will be decided within the next months. I have no exact publication date of the decision, unfortunately, for you. So let's go into output. And the AIPPI resolution. The AIPPI resolution says that on the question of copyright infringement, the usual rules to determine copyright infringement should also apply to output. I think that's a very important statement for, how international law should look like, because to my mind, the existing rules work quite well in order to determine whether output is copyright infringing or not. The infringement test in EU law is if there are copyrighted elements of the original recognizable in the output. That's what I take at least from the Pelham decision of the CJEU, which is of course for the related right of the phonogram producer, but I think the test is also fine for copyright, for genuine copyright. There will be something, I think, on the infringement test of EU law in the coming MIO USM HALA decision, which is due, I think, next week from the CJEU. So this is an applied art furniture decision. So maybe there will be something new on on the EU infringement test. What I think is an interesting one, not answered by the by the AIPPI resolution, is how about double independent creations of an AI system? So if the AI system was not trained with the original and still it reproduces an infringement, is there a privilege for the AI model of independent creation? Of course, this privilege exists for human beings. If you write a novel that is very similar to an older novel and you can prove that you created it independently without knowing the older novel, then it would not be a copyright infringement. That's a so-called double creation privilege. I don't know. Maybe that's also up for discussion.
But in this case, may I ask you something? Who would have to prove that it was independent creation? Who bears the burden of the proof?
Of course, the defendant, the one who did the younger creation, and that's of course how many of these cases die as well. So because it's very difficult to show that you didn't know the older work. But maybe with AI, that will be easier because, if the AI company can prove that they didn't train with the older work, maybe that gets easier because you should know as a company, speaking of transparency as well, what went into the system. But I think at least it's an interesting theoretical question. So the AIPPI resolution goes on saying that output should not be a copyright infringement for the sole reason that it is in the same style as the copyrighted work used to train an AI system, and that that training the AI system has infringed copyright in that work. I think the last one is quite clear. Illegal training doesn't mean that the output is illegal and infringing as well, because it may just not be recognizable, the work you used for training in the output. And of course, style is not copyright protected. So if you just imitate the style in the AI output, that can also not be a copyright infringement. That's at least what AIPPI thinks should also be the general rule on an international level for AI output. I think this is correct. We shouldn't change the copyright system and make style copyrightable just because of AI. If you imitate the style, maybe that's an unfair competition issue. If you do that, in an unfair manner, but it's not a copyright issue, I think.
I'm sorry, Professor Nordemann. I have also, let's say, a note from Mr. Christodoulou, Professor Christodoulou, that he said, I think the burden of the proof lies prima facie with the defendant only if the presumption of copyright is rebutted. I think this is a prevailing view in Germany.
Yes, it is. So just going back to the independent double creation privilege, yes. So in Germany, and probably also in Greece, I suppose, if you want to rely on the privilege of independent creation, you as the defendant have to prove it. And that's why I have not, in my lawyer life, which is more than 25 years old now, have seen a successful case of double creation, of, the double creation defense yet. Because I've seen it in several cases, but always the defendants failed to prove it, that they didn't know the older work, the original work. But that's what I said earlier, is maybe in AI scenarios, it's easier to prove for the AI operator that something did not go into the system, at least in case the AI knows what went in, what they used for training.
I have another question, but it has to do with the style. Dr. Tsigu, a lawyer, she asks, can we have same styles without feeding the AI system with protected works? So actually, it's like,
Probably you need AI training to imitate the style. You need to train with the works. So, for example, if you want to paint a painting Van Gogh style, you need to train with Van Gogh works, probably. But if you do that legally, I think there's no point of declaring illegal
the output
that paints in the style of Van Gogh. Although he's out of protection anyway, but just as an example. Let's look at EU law. What are the rights infringed by AI output according to EU law? And I think reproduction and making available to the public by the AI provider are the relevant rights that could be infringed. And on the liability part, AIPPI says, all can be liable. The AI system can be liable. The AI user can be liable. It's a question of the individual case. And that's a nice kind of, EU law would probably, regarding the liability rules, differentiate between direct and indirect infringement and say, direct infringement, if you're actively involved, you're the primary infringer. And indirect infringement, there are certain rules, in particular for video sharing platforms, YouTube Suando decision of the CJU. So even in case you're not the primary infringer, you may still be liable for copyright infringement as an indirect contributor, according to the rules set up in YouTube Suando in particular for making available. And that is very interesting. In the GEMA decision, the court said the output is an illegal reproduction of the lyrics. Again, we are talking about copyrighted lyrics that were at trial. So the output is an illegal reproduction. And I think what is really interesting, they said it's not the user who reproduces, it's OpenAI who is the reproducer. because, again, the argument is it was so simple to get the lyrics out of the system that it is a reproduction by OpenAI. So it's just to kind of push a button and it comes out of the system, because prompting was so easy. So the reproducer is not the user, but OpenAI is so, which is, I think, very important because, for example, OpenAI cannot rely on the private copy exception. And the private copy exception follows who is the reproducer. And in case OpenAI is the reproducer, no private copy exception, which may be available for the user.
That's very interesting, and I didn't know about the gamma, so it was really about the game decision. Just to mention, because not to leave these comments without saying, and sorry for interrupting you. Mrs. Tsigu thanked you because probably she wanted also to have this, that legal training is necessary in order to get the same style. And Professor Kalinikou, she said the style that we said also style is not protected by copyright. That's why probably we had this, this issue. I'm sorry for interrupting. Just wanted to keep it updated.
I think at least the style, the last remark is style. That's the prevailing view in the entire world. I think that style is not copyright protectable, and why AIPPI emphasized this was just for the reason that we should not change the copyright system as it stands just because AI emerged. As I said, maybe it's rather imitating the style is maybe rather an unfair competition issue than a copyright issue. Okay, let's return to output and reproduction. As I said, really interesting that the court held OpenAI to be the reproducer. Of course, this was then infringing because there was no exception available for OpenAI. What is also interesting is that the court said, well, if it is possible with simple prompts to repeatedly get the lyrics out of the system, you OpenAI, also make the lyrics publicly available. As a successive public. So not to a sufficient public parallelly, but a successive public is sufficient according to the CJU case law. So that's, of course, also liability on the side of OpenAI, public making available, and they need a license for that as well. In the resolution, there's a part on sanctions as well, which we will now skip because we are running out of time anyway. Just to maybe conclude, and then maybe if you still have time, enter into a discussion. So AIPPI said harmonization of laws in the international forum is desirable. AI training, we should have the TDM exception could work in Article 4 DSM directive, but it should be compensated if no opt-out by the rights holder. Transparency should be lived strictly and really be useful to make right holders identify if their works were used for training. The OpenAI decision of the Munich court confirmed that Article 4 applies to AI training, but Article 4 did not really apply because the court held that there was a permanent copy in the model through memorization. For AI output, the usual rules to determine infringement should apply according to AIPPI. Looking at liability, of an AI provider for unlawful reproduction in case of active involvement, this Munich court confirmed that OpenAI was the reproducer and was liable for a direct reproduction, and regarding liability of unlawful making available of the AI output to the public due to successive making available. This was also confirmed by the Munich court in the GEMA case. That's all from my part, and so I look forward to the discussion.
Thank you very much. I like very much the connection that you did, not AIPPI resolution, EU law, and also you make the combination with the GEMA decision. Really nice. You make it, let's say, holistic approach, as they say. We have already the first question in this question and answer section, but I wanted to say to you that whoever has a question, I can, let's say, raise a hand, and I could give the possibility to see him or her and, and ask the question, so make it more interactive. In the meanwhile, I read the question from Mrs. Olena Moroz, I think it's Mrs. or Mr., I'm sorry. Can a research organization that relied on the exception be a copyright owner of the outcome? If yes, it would mean that their copyright is automatically restricted, non-commercial use, even if the outcome work is sufficiently original. Oh, no, it's not a question. If yes, so can a research organization that relied on the exception be a copyright owner of the outcome? If yes, it would mean that the copyright is automatically restricted, non-commercial use, even if the outcome work is sufficiently original. This may perhaps make exceptions less attractive.
Yeah, I think that's a fair statement.
Mm-hmm.
Because if we construe the exception, the training exception narrowly, and say it only allows non-profit output,
mm-hmm.
then it would make it really, as the question suggests, much less attractive to train for non-profit organizations, because they would really have to also control, where the output goes. And yeah, that is true. But I think probably, this is our copyright exceptions are all about a fair balance
mm-hmm.
of the interests. And if you allow, like Article 3 of the DSM directive, allow training, for on a quite wide basis, it's not only AI training allowed without compensation, but also permanent reproductions are allowed according to Article 3. This probably, should also result in somewhat more limited use of the output. I think that's a fair balance. But of course, you can have a different opinion on that.
And of course, Article 3 is only about the exception to the reproduction and not the communication to the public. So they cannot be used, let's say. It cannot be used. Although in Germany, I think they have also included the communication to the public.
And no, the exception on Article 3, the implementation in German laws, also only on the reproduction right. But mm-hmm. I think it has a certain connection to the output. Because if you are really strict on the non-profit requirement, you have to include the output. The output also needs to be non-profit, because otherwise, well, I think the abuse possibilities for the exceptions just get too broad.
Okay, I have 2 comments from Professor Kalinikou. And afterwards, I will give the floor to Professor Christodoulou. Professor Kalinikou states that EU rules exclude machine-generated outputs because they lack the personal stamp of human authors. What about opt-in instead of opt-out? The one is a statement. The second probably is what is probably your opinion about instead of having opt-out, as already we have in Article 4, what about opt-in, if I can, let's say, interpret it here? Question. Afterwards, I will give the floor to Professor Christodoulou.
Yeah, I think this is a good question as well. And of course, you can really question if an opt-out system strikes a fair balance for copyright holders. Starting, for example, with the Bernd Convention that says there should be no formalities to enjoy copyright protection. If you have to opt out, well, that may be a formality. And also the opt-out system, if I think we are honest, at the moment doesn't work because you have no international standards how to do the opt-out. It's very unclear how, what you have to do to opt out. And the only really safe way to opt out is to do it in the robots.txt proactively. So you as the copyright holders have to go into the robots.txt and kind of identify the AI crawlers you don't want. And that's, I think you also have to kind of renew it more or less every day and think of who could be a new name for an AI crawler. I think that's not, at least it's not a feasible solution at the moment. So you have to either develop standards that really work and the opt-out is easy, or you have to think maybe about going to an opt-in system. You're muted, Daphne?
I'm sorry, yes. Let's try to give the floor to Professor Christodoulou. Yeah. Professor Christodoulou?
Yes.
You have the floor.
Do you hear me?
Yes, we can hear you.
Yes.
But you cannot see me.
We cannot see you, but it's important to listen to you.
Never mind. Yes, of course. The speech matters more. So, first of all, let me thank you, Professor Nordemann, wholeheartedly for this so interesting and fruitful and full of stimuli presentation. Let's take the advantage of this whole event to invite you, perhaps, in order at last to visit Greece, so that you at last visit Greece, to invite you in our university. I happen to be the dean of our law faculty. Now, as of the essence of the presentation, I'd like a brief comment on an old German idea, this idea of verblasenen Werken. How do the Pelham criterion, as well as the AIPPI provision, could apply to such works? In order to be a little bit more clear, you have, of course, understood me. Could we find applicable the criterion of Pelham, the recognizability, upon the works that have already are in a distance from their origins, from their original material? So let's stay here, and thank you once more.
Yeah, thank you for the question, Professor. It's a question regarding, just for the others to maybe explain a little bit more the background, it's a question on the infringement test. Under German law, you had a test in the past that in German would call verblassen, which means fading away of the original. So the fading away of the original theory, it was called. So whenever the original fades away sufficiently out of the new work, there's no infringement. I think, and that's also the case law of the German Federal Supreme Court, the very recent one, a 2022 decision called Porsche 911, which kind of puts this into a new context and says we have to reinvent the fading away theory and adopt it to union law and say whenever a work is recognizable with its copyrighted elements, so the copyrighted elements need to be recognizable in the output, then we have an infringement, which could be justified by exceptions or so, but it's first of all an infringement. So the old fading away theory is kind of narrowed down, I think, to a considerable extent to recognizability, more or less, of copyrighted elements, of course, not of non-copyrighted elements, but of copyrighted elements. So it is a little different, I think, interpreted in union law. And if you're interested, I could send you the Porsche 911 decision, which exactly deals with the issue and kind of reinterprets the fading away theory.
Professor Christodoulou, do you want to say something?
No, simply I'd like once more to thank Mr. Nordemann.
Okay.
I feel gratitude.
Okay. Does anybody else have a question? If not, if it is not the case, I had the last one. If I may, and if it's possible for you, because it was, let's say, it was not prepared. So how do you see the Gamma decision in comparing to get images against Stability AI? Just very, if you can, and if you have the time, and just to very short, let's say, comment on this.
Yeah, Daphne, this is an excellent question, of course, and our plan was to mention it, but somehow I got past it. Yeah, it is interesting. The Getty decision also is about the memorization of Getty pictures, where they own the rights in the Stability AI model. And the UK court denies this. So this is a big difference to the Gamma decision. And my takeaway is really the facts were different. The facts were much better in the Gamma case, and the fact seen from a perspective of right holders, and the facts were less good in the Getty case. So I think it's a factual difference. Of course, you can also question if the legal argument by the Munich court is correct, that whenever a model is able to put together information that is available in the system, put together to identically reproduce repeatedly the same copyrighted work, maybe that's not enough. There are voices in German academic literature that say a copy needs to have a certain corpus, and it is not sufficient that you have information all over the place and the device just gathers it. So you need to have a certain, delineation of the copy. That's an argument, but to my mind, I think this is not really convincing, because you can also abuse the argument of corpus delineation of the copy, because then you would just kind of distribute the data all over the place, and you would no reproduction could be found. Yeah. So, but to make to summarize my answer is, I think difference in facts is probably crucial to Getty against Gamma.
Yeah, that's also a little bit more helpful, because otherwise it makes it a little bit very contradictive, the two decisions. I think, a last question from my colleague, from Maria Sinanidou. She thanks you for the presentation, and she asks you, do you know, or how do you think that this CARD decision will affect the way CMOs, its licensing policy?
So it was Gamma, of course, it's CMO, the musical CMO in Germany. And it was kind of their openly declared goal of this lawsuit to open up licensing, a licensing market for them. So they will use, in case the case is further successful, they will use it in order to license. So they have no, I think for them, injunction or so is not an option. They want a license. And so it's for them, it's a big success in opening the licensing market. And I think a lot of other CMOs are looking at the same market.
So it's in one more argument, let's say, or weapon in order to be more convincing to this to the licensing. Okay, yeah, useful, nice. Do we have another question? I don't see. And given the fact that, let's say, it's 3:20, I think at this point, I will really thank you. It was very nice and very informative, and I mean it. I really enjoyed it, and also I learned some things that I didn't know, so it was really helpful for me, and I hope it was helpful for the attendees. Thank you, and I hope the next time we will welcome you here in person in Greece, since there's, let's say, this small wish that has not been fulfilled. Maybe there will be one wish fulfilled, tick, and will help you to this. Also, thank you, Dr. Liberis, for being here, and of course for all the attendees that stayed and watched this very interesting webinar. So till the next time.
Thank you so much for having me. Bye-bye.
Thank you.
Thank you.